All right. The situation there was counsel it was really out of his hands. He indicated that his client said they don't want money, they want possession of the premises. There is ill will between the new owner of this premises and the tenant. There's emotions involved in the situation, and I think it's really outside of the attorney's hands. There's nothing really he can do at this point except say, you better get your client a place to live because she's going out, and money no longer talks.
The Legal Aid Society neighborhood lawyer must function as a go-between, a negotiator, conciliator. He must be an expert at stitching back together human lives, human problems. The Society's 14 neighborhood lawyers, 9 of whom are Negroes, are aided and assisted by local law students. Some of these are volunteer helpers, others work part-time and are paid employees. Assisting Roger Hurley at the Glenville office is Bob Wilson, a student at Western Reserve University Law School.
Was to oppose their standards upon society, the community in general. Is it a national standard or is it a contemporary community standard?
Yes, now, in this recent case, the court has suggested, in Yacobellis, they suggest a nationwide standard.
I think working as a law clerk, as a law student, anywhere is beneficial, and especially with this legal aid program, I feel that working so closely with the attorneys involved and in the final analysis, the clients themselves, has taught me so much more about the law, so much more about people, and I think I've learned a great deal about what the attorneys do day in and day out, which is something that you don't learn in the law school, and they can't teach you in the law school.
One of the kids got...
Another valuable asset to the neighborhood lawyers like Roger Hurley is the information furnished by the Society's investigator, Anthony Jones.
No, that our boy was not driving the car. The other kid indicated that he did not acknowledge to our client that he had actually stolen the car. And I couldn't completely understand that, And there was another kid that has a terrible record in juvenile court. And I don't know what they're going to do about him. They're giving him a small stay so he can complete the semester in school. And then they're going to send him back down.
What does our boy say? Did you talk to him?
Our boy has complete amnesia according to the medical records at the Metropolitan General Hospital. And at this time, there's so little we can do. But as you know, he's going to be tried over in Common Pleas Court. He's not going to be in juvenile court. So it's so little we can do about his memory. We're not doctors.
What do the doctors say about it?
The doctor says there's a possibility that he may never be able to remember this incident.
Well, where does his memory leave off? What does he remember? What doesn't he?
Well, he remembers a lot about the day before. But when this car was totally demolished, he was the most seriously injured. Didn't the police for the kid?
It is a part of my work to counsel people in the problems of consumer nature. The poor people have the same tendency to wait until the last minute to get the lawyer as anyone else, or as the dentist, I'm sure, faces the same problem. I don't get the case until she's pretty well dead on consumer. We get a lot of automobile problems. And it's usually from these outfits, which deal primarily with, we'll take you, whether you've been through bankruptcy, whatever you've been through, trusteeship, doesn't matter to us. We love you, and we're trying to help you.
Sometimes cases involving consumer purchases get quite involved. Legal aid neighborhood lawyer Howard Rawson from the 55th Street office describes one of his auto cases to Roger Hurley.
As we get into the case further, we seem to... Let me take a look at that. All right, as we get into the case further, Raj, we seem to have a situation here where, if you'll notice, the date on the contract is 12/16/66, whereas on the finance company statement of the loan, the date of the contract is shown as 12/27/66. Appears in this situation that the car lot actually made a new contract for this man. Now, you also see that the original purchase amount of the loan is shown as $1356.41 on the finance company statement, whereas it's shown as $1346.91, which is also another discrepancy.
Right.
And we have the amount of monthly payments at $70 a month rather than $55 a month for 24 months, as was explained to him when he came in to buy the car. So it looks to me as though we've got definitely a fraudulent contract situation. And then In addition to this, when the loan was finally approved by the finance company, the check was issued payable to our client in the amount of $1,355.81, which is a third different amount than we had originally. None of the amounts actually correlates to the original amount on the contract. I had the client come in, and I went over all these papers with him, and we found upon receiving a copy of the draft from the finance company, lo and behold, we have a situation where the endorsement on the back of the check is not the endorsement of our client. Therefore, we have a situation not only involving a fraud on the original contract, we have a forgery on the note. I would say that we have a fraud situation. We have a forgery situation on the negotiable instrument. I think also we have a question of unconscionable contract under the Uniform Commercial Code.
Would this be one of those lots that cater to people who are poor credit risks and things like that?
This is true. However, in our case, we have an unusual situation because the client has fairly good credit. This was a situation where he heard this company's advertisement over the radio and drove into the station, and the smiling salesman said, "Sign here on the dotted line and you can drive out with a relatively new car, which is 5 years old." And this is, I think, what happened. This is a gentleman who is of mediocre education, and I think that he was literally sold a bill of goods.
What do you do about the forgery?
Well, I think what we'll do in this case is see what we can negotiate with once we file our contract. I don't know whether we will take criminal action or not in this case.
Don't you want to have an obligation to?
Haven't made that determination. Well, my thought is that the Attorney General's office should be called into this case, and we should discuss the ramifications with the Attorney General's office based on the assumption that if the check were sent directly to the car dealer and the car dealer forged the signature, then, of course, the Attorney General's office certainly would want to look into this for the question of revocation of the corporate charter. And I think certainly in a situation like this would be in order.
During the first 12 months in operation, the neighborhood law offices have made an inroad into a sometimes skeptical population that has grown used to the charities of an affluent society.
And the poor person knows that the only thing they can get is free. And if it's free, it's probably worth just about that, zero. Whereas the middle-class person knows that as long as I'm paying, it has got to be justified by service. The poor person doesn't have a hammer, whereas the middle-class person does, and that's the dollar. So the poor person really doesn't trust the free service they get because it is free, and because they know that unless they pay for something, it's not worth anything. They have this feeling. And it hasn't been until the advent of the federal government's economic involvement in the community that they're slowly beginning to trust this